culpable.
We've got Attorney at Law Martin George on the line, also member of the Police Service Commission. Martin George, we were just taking a different tack on this entire story involving Jack Warner, and especially the element of his sons assisting the U.S. authorities and providing them with information that would have been responsible for the indictment to be placed against him.
Yes, hi, good morning.
Morning,
Good
Mr.
morning.
George.
Good morning to you, Edison, and
Dr. Haywood, morning, sir. Dr. Wayne.
Dr. Wayne.
Yeah,
Yes.
Well, we missed you. Good to hear your voice on this Corpus Christi Day. I had to put that in.
Sure, no problem. It's always a pleasure.
Yes. Now, the latest revelations, Mr. Warner saying that he will do everything in his power to cooperate with the authorities. He will spill all the information that he has. Possibly it's information that could, make things very uncomfortable for Mr. Sepp Blatter. And this is in direct response to the releasing of information from the 2013 statements made by Chuck Blazer when he spoke with the U.S. authorities and gave them information that was used to help bring down Mr. Warner.
Yes, well, the thing is, from what I understand, Mr. Blazer's statement is not anything recent. It's apparently a statement that was given 2 years ago. It's only recently been revealed to the public in terms of its content and the depth and the breadth of such a statement. And I think also from what I heard and saw on the television last night with Mr. Warner, and interestingly enough, it was also on CNN this morning. In fact, they carried a clip from his meeting last night. That was on CNN this morning. His ILP meeting last night was there. And I think the gamut of his approach or attack, if that is what you can call it, is not just limited to Sepp Blatter. I think Mr. Warner is also trying to make direct references to the current government in Trinidad and Tobago and its ascension to power, which he alleges he was instrumental in doing and achieving. And also I think he wants to make a link between the source of funding that would have assisted in that process. What I find of interest, though, Jessime, is the question of Interpol issuing these red notices, because to my mind, the way Interpol functions, Interpol doesn't of its own go out and seek to issue such notices. It's always at the request of someone. And when one looks at the Interpol website, they have indicated that this was done at the request of the U.S. authorities. Now, I don't know if it is that Interpol is lagging behind time or the U.S. authorities are lagging behind time, but if the U.S. authorities had also issued the request to Trinidad and Tobago government for the provisional warrant, and they would have obviously been made aware that the warrant had been executed, Mr. Jack Warner had been arrested, he had been brought before the courts, he had been incarcerated for one night, and he's out on bail with reporting conditions, his passport has been surrendered. One wonders what's the utility in issuing a red notice at this time. It doesn't seem to serve any practical purpose if you are really seeking the arrest of a citizen, because the point is the person has already been arrested. Of course, it serves to further humiliate and embarrass Mr. Warner. If that was the objective, then I think it succeeded magnificently.
To all intents and purposes, though, they've made it impossible for him to travel anywhere in the world, even if he does so on a completely different passport.
Well, I think that would have been the situation anyhow, regardless of the fact of the red notice being issued, because at the end of the day, you already had the provisional warrant being issued by the U.S. authorities, and it had been enforced in Trinidad and Tobago. So there's the question of you could seek to arrest someone at the airport or any port of exit if it is that they're trying to flee the country, if you're aware of this. And, of course, if they then flee and are at large, at that stage, it would make sense to then issue the Interpol alert. But to issue it in this circumstance, because the point is no one is in doubt as to where Mr. Warner is and where he can be located and easily found, So it just doesn't seem a logical consequence of the events which occurred last week.
My disquiet is growing and growing after hearing the statement by Mr. Warner, and the fact that whatever secrets he has been keeping for how many decades are all going to come flooding out. And that could have major repercussions for anyone named in any of his statements, regardless of people's perception that he may not have credibility at this point in time. But the mere fact that he's giving out information that could hurt people's public, professional, and personal images, that is something to be very uncomfortable about.
Well, the thing is, remember, Mr. Warner has made threats before. Remember, he had threatened sometime to unleash a tsunami, and nothing at all came out of it. So I would wait and see, basically, as to what the content really is, because in this case, the proof of the pudding is definitely in the eating of it. So we have to see what is really there, because persons may make statements and say, well, I have all this information, and when you look at it and you assess it, it really may amount to nothing. So,
but this time around, he literally has nothing to lose. He absolutely has nothing to lose.
Of course, he has nothing to lose at this stage. But the point is, I always prefer to have the evidence before me before I comment on it. I don't like to speculate.
With the hard evidence that the U.S. authorities have, and there being no charges against Mr. Warner locally, do you think it would be easier to extradite Mr. Warner from Trinidad and Tobago to the U.S.?
Well, the thing is, it's not as simple as saying because there are no local charges, it will be easier. The point is, and I mean, I assume that there's a corollary you are making with relation to the Ish and Steve cases. They were the beneficiaries of a judgment of Justice Ronnie Boodoo Singh, who indicated that, look, in the circumstances of them having fairly similar charges placed against them locally, then he felt that, look, the more appropriate forum in the circumstances was to try them locally.
Yes.
That's not the case with Mr. Warner. There are no local cases, but that doesn't mean that he doesn't have the means and ability and, I guess, the will to seek to exhaust the legal system for every avenue to seek to block the extraditions as much as possible. And, of course, you'd recognize that what he's cleverly doing is to keep the political angle alive at all times so that, as a last-ditch effort, you can always claim political victimization, because without that, there's nothing else. If you look at it in terms of, apart from, the persons who may come forward, on a personal level, his support really remains the ILP supporters. So therefore, he has to keep that angle alive.
Mr. George, Mr. Warner, in the report, he said he's instructed his lawyers to engage in the task of making contact with law enforcement authorities, both inside as well as outside of Trinidad and Tobago, regarding the statements, the documents that he released. Now, Mr. Blatter, Blazer, who is now 70, he's in a wheelchair. He has medical challenges.
Rectal cancer, he says he has.
Right, and Mr. Warner is 72. My question, to get a legal perspective,
and Mr. Blatter is 79.
79. Okay. Do you think that leniency here will be extended to them if they're brought before the courts in the U.S.? Keeping in mind
that could never really be a factor simply because of age. Because we have seen in the past, if you think of things like with General Augustus Pinochet, the Chilean dictator, when he was eventually brought to the court, I think it was at the age of 82, he tried to use, age as a factor to say, well, feel sorry for me. But I don't think the courts necessarily bought that as an example. You'd also remember former dictator Manuel Noriega, right, who was also extradited and brought before the courts. He was at a fairly advanced age when that was done. So the point is the fact of advanced age. Think also of some of the former Nazi war criminals who have been, eventually ferreted out at, very late stages and eventually brought to trial. Think in terms of in Cambodia, some of the Khmer Rouge leaders who were eventually found out after several years. So,
but that had to do with murder. That had to do with murder, Mr. George.
But even more recently, we have the case of Bernie Madoff and that, what was it?
Right.
The pyramid
genocide
scheme.
and murder. So I wanted to get your legal perspective because do you put in the legal fraternity, regardless of the charges, these men you are alluding to here, the charges were predominantly genocide. Yes, Mr. Warner's is embezzlement. It deals with finances. So go ahead. So I just wanted to put
right,
that in.
But using the example Jesse just gave of Madoff, then you also had Alan Stanford. He was not exactly a young man, and he was sentenced to several years.
I think it's 100 and something years, yeah,
more than 100 years, right? Even at his advanced age. So even for non-capital offences, even for financial crimes, which I assume would be the case here, it is possible to still hand down very severe sentences, and your age is not a factor. In fact, I think, to my mind, your age should actually work against you, because at that age you ought to know better.
Yes, indeed.
If you hadn't learned it before.
I just want, for the benefit of everyone listening, just to refresh everyone's memory about Mr. Warner's comments in his statement last evening. We have an excerpt of it that we can share.
Decided that I will no longer keep secrets for those persons who now seek to actively destroy this country's hard-won international image, this country's faith, and the faith that the constituents reposed in me. And at the age of 72 years old, I have no intention of allowing them to deprive me of my freedom. I also wish to say to you tonight that I reasonably and surely fear for my life. I have, as promised, compiled a comprehensive and detailed series of documents, including checks and corroborated statements, and have placed them in different and respected hands. I said to you before, by so doing, I have in effect placed the outcome of those matters beyond even my own reach. Retracting them is not an impossibility. There can be no turning back. These documents treat with my knowledge and involvement in the following matters: the link between FIFA, its funding, and me; the link between FIFA, its funding, and the United National Congress, and the People's Partnership Government in general election of 2010. These documents deal with Section 34 fiasco. They also deal with my knowledge of financial transactions at FIFA, including, but not limited to, its president, Mr. Sepp Blatter. And lastly, other matters involving the nation's current Prime Minister. I apologize to the people of Trinidad and Tobago for not disclosing my knowledge of these matters before.
So, Martin George, you were able to hear bits of that clip?
Yes, I did.
What has me very, very concerned is the fact that he says, I fear for my life. And against whom is he making those allegations that he has received or his life is threatened in some way?
Well, the thing is, it could also be a case of a bit of melodrama here, in the sense that, in the circumstances, you throw everything into the mix. Remember, Mr. Warner is a consummate politician and stage actor. He is extremely gifted in terms of being able to manipulate scenarios, situations. So I think in the circumstances of this world drama, you throw in, this spicy, salacious twist of, possible threat to your life, from forces unknown. And of course, it adds to the theater of it all. So I don't blame him for so doing if that's his objective. But if you really have specific fears and you have knowledge as to who is making those threats or who is, a possible risk to your life, then obviously you would report that to the authorities. And the most effective way of doing that is by a public outing of such persons. He hasn't done so, from what I have listened to in that clip. So it may just, in this case, be, the added theater.
In terms of his legal counsel, do you think that this is part of their strategy to build, a particular image of Mr. Warner and perhaps garner some public sympathy on his behalf?
Well, I would be a bit surprised and maybe disappointed if this were part of a legal team's strategy, because at the end of the day, these are things that I think would be left to the individual in terms of how he chooses to do this. Lawyers usually try to focus on the law and the interpretation of laws, decided cases, and judgments, and authorities in that regard. This type of public drama, I would think that lawyers would hardly want to venture too much into directing that kind of scenario. And Mr. Warner, being the self-made man that he is, I'm sure very few people can advise him in this regard as to how to conduct this type of public relations exercise.
In the terms of the statements that he's already made, trying to make a direct link between FIFA funding and campaign financing for the United National Congress and the People's Partnership, as well as the Prime Minister herself, is he at risk of major defamation lawsuits from any of those entities, and in particular the Prime Minister, whom he out and out said, she lie, quote?
Yeah, well, the thing is, Mr. Warner appears not to ever be perturbed, fazed, or troubled by the threat or risk of defamation suits. He has quite a few against him, and I don't think that is ever a factor that he considers. In this circumstance, however, given the fact that his claims of, threatening to out people are now international news. I followed all the news feeds. It's on BBC, it's on CNN, it's on ESPN, it's on the sport pages also. So everywhere you have publicly what he said last night. It's been played for the world that, look, he is going to make this great expose. So I would imagine that having thrown down the gauntlet to the world, this is not just something that he's saying locally in Trinidad and it's kept here. This is on the international stage. He has thrown down the gauntlet. So I would imagine that he must have something to back it up. Otherwise, he would really end up looking, I think, quite silly in the whole scenario. And, I mean, I'm not sure that people will take him seriously at all thereafter if he has nothing to back up these very powerful and poignant statements that he has made.
But if any of the people at whom he is, whom he's throwing up in this mix with all these allegations fail to take legal action, does that also indict them, as it were, in the at least in the court of public opinion, as being complicit in wrongdoing?
No, it couldn't. But the point is, as I said, in this case, the proof of the pudding is in the eating. So in other words, we all have to wait and see what evidence he's going to come with before anybody can do anything. In fact, I think if someone locally were to try to make a preemptive strike to say that they were going to court for an injunction to stop him from revealing information, then I think the public will view it the other way. They will say clearly that individual has something to hide, hence the reason they've gone to court. So basically, you can't do anything until the information comes out, and then, of course, if it doesn't justify the allegations, then, of course, persons can clearly take actions for defamation thereafter.
Mr. George, as you talk about court, I'm sorry, Mr. Carr, I want you to paint a picture here for us. I'm taking everything to the extreme. Should Mr. Warner be charged and extradited? His sons having collaborated with the U.S. Justice...
As I understand it, he's already been charged.
Okay, so I'm just painting, you help me along, walk us through this, because I want to get your legal perspective for the sake of, for myself and of course our audience. All right, he's charged, he's extradited, and his sons who have collaborated with the U.S. justice system. How does one prosecute? You are an attorney, and your sons are in the court. You're facing your sons. And they're in the witness box. How does one prosecute or question the accused using the son as witness? What kind of questions do you ask? And the father is looking at the son, son's looking at the father. Put yourself in that courtroom and paint a picture for us in this whole scenario. Because
first of all, I don't know that the matters in which the sons may have given evidence or cooperated would necessarily be the exact same charges that were laid against Mr. Warner.
Okay.
So in other words, and I want us to be very clear and very careful, it may be that whatever cooperation they gave may have led to other things, which may have led to separate and distinct charges being laid against Mr. Warner Sr. But it may not necessarily be that their evidence features directly in the charges for which Mr. Warner is now currently a subject of interest. So let's just be clear on that. That's the first thing. Secondly, it is a fact that children sometimes give testimony against their parents. Parents sometimes give testimony against their children. A classic example of that would be like in cases of incest, where unfortunately the young child, may have to give evidence against the father, and indicate what daddy did, in those circumstances. I mean, it's never a pleasant thing. It's always very traumatic for everyone. I can tell you in those circumstances, the judge, the jury, everybody, it's never an easy thing at all. But the point is sometimes it's necessary in the interest of justice for these things to be done. So it can happen, but as I say, in this circumstance, I have no information or evidence to suggest necessarily that this may be the case or that there may be any direct confrontation of, parents and children in the court in this present scenario.
No, can the wife, because nothing is said about Mrs. Warner, she's left out of the whole fray here. Can she be subpoenaed is the term to bring evidence, or how would you get her involved, because she's been out of the picture? And if he goes to court, can the attorney, the prosecutor, as it were, can she be subpoenaed? Because how do you approach this? She's out of the picture completely. I know we have to be sympathetic with how she's feeling right now and the embarrassment probably that she's facing with her family and her friends. But from a legal perspective,
well, I would imagine it's only if there is some indication that she has some peculiar and specifically useful and relevant knowledge and information that would be germane to the proceedings before the court that anyone would show the slightest interest in Mrs. Warner. I think quite wisely, over the years, she has always maintained a very low profile, has never sought publicity or attention, has never sought to be, in any way publicly associated with FIFA or the business of FIFA. So I would think that it may really be stretching it without more, unless there's some revelation that is coming to the fore soon. But I think, based on the past actions we've seen, I think it would really be stretching it to, seek to implicate her even as a witness one way or the other.
What kind of
either for or against Mr. Warner, even, as a witness of character on his part. I don't think he himself would even do that.
Let's just take a call very quickly. Hello, good day. You're on the Breakfast Roundtable.
Yes, Ray. Good morning, Mr. George.
Hi, good morning to you.
Mr. George, please tell us, in what ways could Mr. Warner delay or exhaust the procedure of extradition? Thank you.
Well, once you have clever and competent and intelligent attorneys, you can seek to delay and exhaust all legal proceedings as much as possible. So, I mean, that's on the face of it, the simple answer to that. However, in terms of an extradition, remember, the requesting state has 60 days within which to present the evidence upon which they are relying. So, you then now have to look at two things. You look at the strength of the evidence vis-a-vis the foreign charges, and then also you have to do another comparator, which is that you have to compare the foreign charges to relevant or similar local charges, because it's important that for the receiving state you must have fairly similar or comparative local charges or local offenses. Otherwise, that is a basis upon which to seek to challenge or deny an extradition request. So, say for instance, if you have, say for instance, in one of, say for instance, if it's an extreme Islamist state where they have specific religious laws which, prohibit certain things, and that is the basis upon which your charge is laid, and then you make a request for extradition. If the receiving state does not have any similar or comparative law, then the receiving state or the person who is the subject of the extradition request warrant can then challenge it and say, hey, listen, that is not known to our law locally, so therefore in those circumstances it would not be proper or appropriate to extradite me. And if you look at the Extradition Act of Trinidad and Tobago, that's one of the things that they speak to. So that's just a simple example. And if you notice, the U.S. Attorney General's office spoke of racketeering. There's no racketeering charge on the laws of Trinidad and Tobago. However, you may be able to break down the racketeering charge and look at the essential elements of it and the substance of it, and then you may find similar charges, say for instance, under our prevention of corruption legislation, and then you can say, well, look, even though it doesn't use the title or the nomenclature of racketeering, it essentially is the same ingredients of the charge, so therefore you then now make the comparison. But of course, all of this is subject to legal arguments. People will produce cases, authorities, to suggest one way or the other as to the way it should go. And that's just one way you can, mount a challenge. You can mount challenges on other grounds. The Extradition Act provides that, look, if it is that the prosecution's request or the requesting state is in any way agitated by malice or bias based on someone's ethnicity, gender, religious or political views or anything of the sort, then you can also make that case. So that's why I keep telling you, Mr. Warner is quite cleverly keeping the political angle very much alive in terms of this whole scenario. Hence the reason for always seeking to ensure that, look, he is not going to give up his ILP status easily, because the political angle, it always creates a good and fertile ground for making challenges either socially, theoretically, philosophically, or legally.
So what kind of effect, Mr. George, do you think this swirling whirlpool will have on the election campaign?
Which election campaign? Trinidad and Tobago?
Indeed, yes. Campaign? Yes.
Well, as I say, it could possibly depend on the depth, breadth, and the veracity of what information Mr. Warner has to reveal. Because if he can reveal things which really show that, look, there was culpable knowledge, not just knowledge, but culpable knowledge of, the source of funding which may have financed certain elements of the campaign, etc., then you see, in light of the recent denials, it does then throw things in a slightly different light. So it can have some impact on our elections, but as I say, it can only depend on him really producing the goods, because he has thrown down the gauntlet to the world.
Martin George, we want to say thanks for linking up with us on this Corpus Christi morning, and for giving us such excellent analysis and really breaking down elements of the law for us, particularly on the matter of the extradition treaty. Thank you so much for that.
It's always a pleasure, and good morning to your listeners, Destiny, and to your other co-hosts, Edison and Dr. Wayne.
Thank you, sir.
Have a great day.
Thank you.
Don't touch a button. We'll be right back with more on Sky 99.5 FM.